All right, we're all ready to go.
Okay. Hello and Happy New Year to everyone. My name is Dave Zapponi. I'm the Executive Director of ECHO, otherwise known as the Educational Council of Homeowners. Thank you for participating in the ECHO live stream event on discrimination, cultural sensitivity, and reasonable accommodations featuring Mark Guithues, Esquire. ECHO is a statewide nonprofit association created to support HOA board members and engaged homeowners. Our mission is to foster a better quality of life in community associations through education, advocacy, and connection. Before we move on with the program, please note the following. This live stream webinar is scheduled for an hour and a half, including 20 minutes of Q&A after the presentation. Attendees will be muted during the presentation. Please use the chat feature for technical issues and use the Q&A feature for content-related questions. We will be vetting and answering questions as they come. We will try to answer all the questions, but due to time constraints, we may not be able to. Please always be courteous and respectful of meeting participants. We reserve the right to mute or remove participants at any time and for any reason. This program is copyrighted by ECHO and will be recorded. We do not give permission to others to record the meeting without prior authorization. A copy of the recorded program, along with the presentation slides, will be emailed to registered participants within 7 to 10 days. Finally, none of what is said during the meeting shall be construed as specific legal advice from either the speaker or ECHO. If you wish specific advice, we encourage you to ask your attorney. I want to thank HOA Alchemy for generously supporting our program today. HOA Alchemy automates HOA management processes. The annual cost for a typical 150-unit HOA is $40 per month. Their team will work directly with your association and vendors to achieve extraordinary savings. Most associations have around $5,000 per year they save around $5,000 per year using HOA Alchemy automation. The HOA Alchemy systems also help you with communications. Unified messaging lets board members or managers send the same message to homeowners effortlessly via email, SMS, push notifications, or US Postal Service. Simply touch the button and send it once. Thank you to HOA Alchemy for sponsoring this live stream event. At this time, we will begin our program, Discrimination, Cultural Sensitivity, and Reasonable Accommodations. Our speaker for today is Mark Guithues. He is the founder of Community Legal Advisors, Inc., which represents more than 500 HOA communities. His firm provides assessment, collection, and general counsel services. For more than 20 years, Mark has provided general counsel and civil litigation services to the firm's community association clients. Mark also serves on the ECHO Board of Directors. Thank you, Mark. Please take it away.
Thank you, David. It's a privilege to be here. I want to talk to you about basically helping your association identify and avoid discrimination claims, specifically claims that I'll explain are brought by the state of California against your association. They are funded by your tax dollars on behalf of owners who believe that the association, which is a corporation, or its directors who are directors of that corporation, have discriminated against them unfairly. In doing so, it may be perceived that I am trying to shade or invalidate the claims of the people being made. And my point is not to do that. My point is to that the claims may be perfectly valid, but what is important to recognize is we can identify them up front, we can address them properly, and we can avoid defending a lawsuit from California's Department of Fair Housing. And that's really what I want to talk to you about today. An overview of it is this: owners have the right, tenants have the right, residents have the right to make fair housing claims against the association, alleging that they have discriminated in some fashion against that owner, tenant, resident. That is, that we have treated them differently, and that the reason for treating them differently is based on some race, color, creed, national origin, sexuality claim. And so what I want to do is prepare you as a member, you as a board member, you as a member of your corporation to identify these things before they are brought against you. And so this is what you need to understand. What you need to understand is that the event occurs, the alleged event occurs, and then time passes by and the alleged event is brought to the attention of the association. And we're just going to call it the event. The event is brought to the attention of the association, and the association takes its action, whether it chooses not to take action, whether it ignores the claim, whether it handles the claim in some fashion. Then time passes by, anywhere from 3, 6, 9 months passes by. And then the owner, the person who brought the claim, says, hey, I don't think that was handled correctly. And they register a complaint with either the federal or California's Fair Housing Department. And at that point, the state of California or the feds step in on behalf of that owner and look back in hindsight at the claim, at the event, and how the association responded to that event. So there's nothing that you're going to do real time. There's plenty that we're going to try and do real time in terms of documentation retrospectively. What really matters is how you handled that 3 months ago, how you handled it 6 months ago. So what my purpose is in today's teaching is to bring to your attention these things as they are occurring so that you can see them and you can avoid them, right? So the first thing that we need to get out of the way is the concept that the capital owner or the tenant or the resident needs to prove that the corporation intentionally discriminated against them. And what I want to do is remove that from your mind. That person doesn't have a burden of proof. It is their perception which the state will act on. So if the owner perceives that they were treated unfairly based on race, color, creed, and national origin, the state of California will commence investigating the corporation, the association, to see if it has done so, and will make a thorough investigation, which is generally pretty expensive to the association because what you're going to have to do is get legal counsel involved very quickly. And so that the idea that, well, prove it is an errant thing. Recognizing a potential claim, yeah, we want you to recognize a potential claim before or as it's occurring, so you can take immediate response. By immediate response, we want to have a quick meet and confer with everybody involved. We want to have a hearing to discuss the action. We may or may not want to make a decision, but we absolutely want to implement a process. And we're going to talk about that process over and over again. Now, what is the process? The process is borrowed from the situation where you have a handicapped individual. And I'm going to go to sort of a question that somebody has already proposed, which is, we have a handicapped person living here and he smokes cigars and he's loud and he backs his truck up and the property manager is doing nothing. What do we do? And the answer is, you can probably report it directly to the Fair Housing Department, but I think we are going the wrong direction here. I think what the association should do is sit down with this person. And when we have a handicapped person and they come to the board and they say, gosh, I want to change the common area. Gosh, I want to change the appearance of the exterior of my building or unit so that I can access, ingress, egress, get through the common area to get to my unit. The corporation is required to meet with them. They're required to, quote, engage in a prompt meet and confer. And at that meet and confer, they're required to determine the nature of the handicap. We're not asking what you suffer from. We can't ask what they suffer from. But what we can say is, what do you need from us in order to make full use of your residence? And at that point, the association's required to stand ready to excuse or ignore or set aside its CCNRs, its rules and regulations, its bylaws as necessary to allow that person to have full use of their residence. Now, that has to be a, quote, reasonable accommodation. So the question in your example earlier of the person who just has a handicap placard so they believe they can do anything, that's untrue. What the association cannot enforce is a restriction which precludes this person from making normal, healthy, full use of their home. So let's say that, for example, a person cannot go out in the common area without a dog. They feel unsafe, they feel uncomfortable, they have an emotional handicap, and so they take their pit bull in the common area, right? Well, that is allowed if that pit bull is if the person documents that they need the pit bull. So quick meet and confer with the board. The board says, hey, pit bull owner, we don't want your dog here. And the pit bull owner says, I can't walk through the common area without my pit bull. I don't feel safe being in public without my pit bull. I need it. You say, great, get me a note from your doctor and we'll go to the next step. So they come back with a note from their doctor that says, hey, I am injured. So you say, great. They need to have that pit bull. So now what is a reasonable accommodation? Well, if the pit bull's behaved itself and created no problems, then we're going to let them walk across the common area, even though the CCNRs or bylaws or rules say no dogs allowed. We are going to make a reasonable accommodation to let this person walk across the common area. Let's change the facts a little bit. Now the pit bull is a snarling, barking, fighting animal, and the person who has the dog claims the before facts. Okay, so again, the association's obligated to make a reasonable accommodation. They have to waive their rule saying no dogs, but they can come back to the dog owner and say, hey, that's fine, and we're going to allow you to keep your dog, but your dog's going to have to wear a muzzle when it's on the common area. That's a reasonable accommodation to allow you to have your dog while others around it are safe from the impact of your dog. Same reason the dog has to be cleaned up after. The dog can't bark all night. The dog, right? We can have the dog for our purposes, but the purposes can't be unreasonable. I can't take the dog into the pool. That would be inherently unreasonable, because the minute a dog hits a pool, health and safety regulations say that the pool has to be drained and not used anymore. So just because I have a need for a companion animal doesn't mean that I can take them into the pool. That's inherently unreasonable. So I want to talk to you about that process. That process is meet and confer very quickly, and then come to a reasonable accommodation. Okay, so now we're going to apply it to kind of some other facts. Hannah, let's go to the next slide. The question is, who can bring a claim? This is a shocking thing for most directors, because the answer is that anybody can bring a claim. If an owner believes that they are being treated differently than the other owners based on race, color, creed, sexuality, national origin, and yes, age, then they can bring a claim against the association. So too with tenants. So if there's a dispute between a couple of tenants or a dispute between a couple of owners and a couple of tenants, most boards just say, well, those people are tenants and we're not going to worry about that. And the answer is no, we need to worry about that. We need to pay attention if the dispute arises out of race, color, creed, national origin, sexuality, age, etc. What about guests? Well, if the guests are there quite often, then they have a right to be protected. Employees and vendors, you bet. The example I'll give you, my favorite example in there is what we call a doc in the box. We call a manager in a box, and it's a situation where you have a high-rise association, and you got those 4 elevators that go straight down to the first floor, and right outside the first floor is the manager's office. And people go by and flip off the manager, and they misbehave, and they call the manager's names and that kind of stuff. When that manager files a unhelpful work environment claim against the association can cross complain against the individual owners who are misbehaving. And so it's those employees, those vendors, those are all protected parties. Why do I have fair housing in here? To talk about who's gonna actually physically bring the claim. All of these people could complain to either California's Department of Fair Housing or the federal Department of Fair Housing Department. That's the inference. But what happens is the federal brings the proposed action to the attention of the state of California. The state of California then brings the action. Why? Because the state of California both has funding for this, and they have a much more expansive law, which is to say that anything illegal under the Federal Fair Housing Act is illegal in California, plus a few more. So let's move to the next slide. So what are the laws that might be violated by a homeowners association? Well, you already know that not ADA, but failure to make an accommodation for somebody who's handicapped, an owner or a tenant trying to make their way to their unit and that kind of stuff. That's a violation of the Fair Housing Act. We in homeowners associations, not so bound by the Americans with Disabilities Act, which has to do with public accommodations. But if you're living in a mixed use project with commercial and residential units, then you should expect that actions will be brought under the ADA, because failure to set up your parking properly, failure to set up access in and out of those public accommodations, those actions are brought under the Americans with Disabilities Act. Then back to the Federal Fair Housing Act. At the state level, the feds defer to the state, so we operate under the Fair Housing Act. We also operate under the Unruh Act. Now, how does that come about? Well, the Unruh Act has some discriminatory rights and some non-discriminatory rights. So let's talk about it. The Unruh Act, Civil Code Section 51, point 3 and point 11 allow an association to legally discriminate against people below the age of 55. Specifically, they can't occupy a residence in a senior community, right? It's an example of permissible discrimination. On the other hand, those associations who blanketly exclude children who are not senior communities, or who set up rules and regulations based on somebody's age or childlike propensities. So if you make a rule that says no playing in the driveway, or no playing on the common area, you are going to face the wrath of fair housing, because playing is a thing which they believe is inherently discriminatory or associated with childhood. And their point is, no, it's common areas. Children have the exact same rights that adults do. And so if you want to close an area to access, that's fine. But if you are going to try to state that somebody young can't go through an area that somebody who is older can, then we've got a problem. So when you write your rules and regulations, run them past an attorney, make sure that we're not dealing with a situation where we're talking about, no bike riding as opposed to no playing on bikes, no children on bikes, that kind of stuff. So we want to be very careful of rules and regulations like that. And then there's local building codes that we need to be aware of, that we need to make sure that we meet so that folks are treated equally. So when we do major improvements to our buildings at homeowners associations, oftentimes the local building codes require that we bring those bathrooms, those common area facilities up to ADA standards. So again, local building codes might trigger ADA standards even when the ADA itself does not. Why don't you go to the next slide, and I'll try and take a look at this anonymous attendees question here. When we have a vacancy, we use a committee to review applications and recommend new members to the board. Over time, we choose, over time, we consistently choose straight white members. What can we do in our application to attract diverse, minimize implicit bias, prioritize section of people of color? I think you put that exactly into the application. I think you put that paragraph right into the application. We say, you know, because the majority of our members have historically been straight white, it may appear that we don't encourage. In fact, if you the purpose of the sentence is to attract diverse applicants and minimize implicit bias through the application process and prioritize selection. So you can get from here to there just exactly how you mentioned it. When is an association required to address a third-party discrimination? Well, this is a hot question, and it's not a question anymore. It used to be a question, and I'll tell you the case that we dealt with, and it was Reeves versus Carolsberg. So back in '97, we had a situation. You know what? I'm going to read 24 CFR 100.7 just to overview it. A person is directly liable. So that's anybody, the corporation itself, the individual directors, members of an association. A person is directly liable for subparagraph 3, failing to take prompt action to correct and end a discriminatory housing practice by a third party, where that person knew or should have known of the discriminatory conduct and had the power to correct it. So let's hang on to that. That's the law that was passed a little over 3 years ago in form of Code of Federal Regulations. Why did that come about? It came about because of Reeves versus Carolsberg. And in that situation, we had sort of an African-American woman versus a bigot. And it goes like this. She was a government worker. She went to work every morning. He sat outside the house and called her the N-word and called her all kinds of names just for sport. On various occasions, he told her that he would probably rape her when she came home from work. This was really horrendous behavior. She reported it to the association. The association said, too bad, so sad. That is a member-to-member conflict. And the Department of Fair Housing sued the association and said, heck no, this is something within your control. You needed to do something you needed to try something under your governing documents to stop this behavior. That case came to a stalemate. The case came to a stalemate after 4 years. Essentially, they settled because the Department of Fair Housing did not have the language to your left. They did not have a bullet. They did not have an active vehicle to bring action against the association for failure to take action. And ultimately, it settled with the association agreeing to buy Mrs. Reeves' unit. And so that it could be sold to a third party, fully disclosing the fact that bigot lived next door. So after that, we had the 24 CFR 100.7 passed, making individual members, wherever they fit, whether director, board member, or that kind of stuff, to making them obligated to be part of this solution. Now, Now, on the other end of the spectrum, right, the pendulum might have swung, right? What happens when we have people of multiple race yelling and screaming or in conflict with people of multiple races? Well, that's what happened in Lawrence versus Courtyards. And I brought this out so that you could understand that this is why we say that we focus more on a process for the board than necessarily coming up with a solution. So let's talk about Reeves versus Carolsberg, and you can see, let's talk about Lawrence versus Courtyards, and you can see where I'm going here about process. In Lawrence versus Courtyards, the Courtyards Association knew that they had a conflict between an African-American couple and a, quote, diverse community of Eastern Indian, African American, Hispanic, and Caucasian people. Okay, so down in Florida, we had a family that was in constant war with some other families, and they were responding in kind. So the association had a hearing. They had a hearing. The association invited in the Lawrences, and they invited in the balance of the community. And what they determined is that, while the Lawrences certainly had something to complain about, the other people all said, hey, wait a minute, Lawrences flip us off. They call us fucking Indians and all kinds of, racial and ethnic slurs based on our color and creed. So at that point, the court dropped the action against the association. The court dropped the action against the association and said, okay, the association, maybe I jumped to the conclusion, but the association was able to show that they held hearings, that they talked to each party, that they counseled each party to stop the behavior, that they told the parties that it was against the Fair Housing Act and that the action could not be tolerated, it was not acceptable. That's what they did. They did not fine anybody. They found that people were kind of equally responsible. And so when the lawsuit came through against the association, Fair Housing swooped in and they said, okay, well, you didn't behave properly. And the court came back and said, yeah, they did. They did notice, they did hearing, they listened, they documented, they told people that they had to change the behavior. They did what they could under the governing documents. And so for that reason, Lawrence versus Courtyards is a great case because it begins to shed light on what happens in the fair housing analysis, which is to say that they go in, they take a snapshot from 6 months later or a year later, and they look and they say, was that handled correctly? And what is the correct way to handle it? Hold a hearing, bring people in. So let's go to the next slide. I want to make sure that I'm covering the questions as we go. Are we allowed to offer membership to an applicant because they are a person of color if we want a more diverse membership? So most membership is based wholly on ownership within community associations. So just offering membership wouldn't be a sort of typical thing to do. What not to ask. So now what I've told you is you need to have a hearing. You need to sit down and do a meet and confer, and you need to ask them, essentially, what do we need to do to make a reasonable accommodation for your needs? So what do we start with? Do we ask, what is your disability? No, we don't. We don't say, can you prove it? What we say is, can you provide a doctor's note as to the thing which you are asking is necessary? So again, we can ask if they have documentation, but we wouldn't ask if they are handicapped. And this is kind of a trick situation, and I'm going to advise you to bring in counsel, because it kind of goes like this. If the person walks in towing an oxygen tank, you already know what the problem is, all right? you know that they have trouble breathing, and that's going to affect the ability to walk upstairs. That's going to affect the ability to, do normal life things. And so you should already be on notice of sort of the things that they are going to ask you to do. And that's the expectations of the court. So I'm absolutely here telling you a fourth way. Do not ask people what their disease is. Do not ask people what their disease is. Ask what they need the association to do in order to accommodate them. Can you ask for documentation? Yes, you can ask them for a doctor's note that the accommodation that they're asking for is consistent with their illness, right? So if you have somebody who's walking with pulling an oxygen tank, you can be pretty sure they're asking to park closer to the front door. You can be pretty sure that they're asking to maybe park illegally in front of the place in a way that allows them ingress and egress easier. But the key is to have that meet and confer, and then start talking about what the association can or reasonably should do in order to assist them. And it's okay to say that's not reasonable, but what if we did this and put it back on the owner? Those are fair questions to go forward with. So let's go to the next slide. What are the limitations on the association's power? Well, that's a good question, because it really is there's an inverse question, which is, what is the association obligated to do? So let's start with California Civil Code 4760. 4760 says that if somebody has a handicap and they want to change the common area in order to create access to their unit, in order to maintain or improve access to their unit, that the association has to allow them to do it. And there's some caveats in 4760, things like, but the association can require that they remove it after they leave. That never happens. But the association can do this or that. The point is, the big caveat is that this needs to be, or is supposed to be, at that owner's cost. So the association should not be obligated to come out of pocket to make physical improvements on behalf of a handicapped owner. Now, should they? Well, that's a different question. So I represented an association down in Carlsbad, adjacent to the La Costa Resort, and they're a timeshare. But they had an owner come in who lived in there full time, and they said, and that owner said, "Look, I'm handicapped. I'm in a wheelchair. I need to have a ramp into the entry to the building." And she made proper architectural approval, and the board looked at the ramp and said, "Oh, holy shoot! This is not going to be just a handicap ramp. This is going to be a skateboard ramp for everybody staying at every 14-year-old staying at the La Costa Resort." And so they kind of stared at it for a while, and they said, "Well, what are you going to spend on this?" And the owner said, "I'm going to spend better than $6,000 on it." And the association kind of sat around and they said, "What if we took your $6,000? What if we put in some association dollars and we built a permanent, more beautiful ramp that's appropriate for the entry to our building?" And that was the compromise. And when I talked to the board's feeling was, hey, we're all getting older. If she needs this, we're going to need it when we're in a wheelchair. So let's just bite the bullet and address the problem now. So I want you to recognize that some of these things are opportunities in wolf's clothing, right? So they look bad, and the board wants to say, well, God damn it, they're not really injured and all that kind of stuff. And I say, I think that this could be an opportunity. Let's take a look at it. The case that I want to talk to you about is sort of the most recent line on how far a court will expect an association to go. And Gittleman versus Woodhaven, a handicapped man wanted an exclusive use parking space. More specifically, at this association, these guys kept track. This must be a New Jersey or Florida thing, but if you were the oldest person, you went to the top of the list and you got the nearest parking space. And these guys kind of rotated parking spaces based on who was the oldest, and whoever was the oldest held the closest parking space to the front. So there's sort of this waiting list, if you will, kind of omnipresent at this association. Why does it matter? Because a handicapped guy said, look, I want a parking space up at the front of the list. And the association said, we can't do that. You know, that's not how this list works. And the association sat and basically shot down Gittleman. And so it turns out that this process was in the CCNRs. And so they said, well, look, it's going to be a violation of the CCNRs. So there's nothing we can do. Well, if you read the CCNRs, it said that there should be a hearing wherein somebody who needed the space better than the other people should have the opportunity to come into a hearing and tell the people who are ahead of them in the line and allow them to exchange spaces in the line. And the association didn't do that. And so the association lost. They lost in federal court, not because they were required to buy a space or spend money to renovate a space or do anything. They lost because they hadn't followed all of the possible steps in their governing documents. They want the association to follow every administrative step and opportunity in order to meet the standards of the Fair Housing Act. So, are we doing everything we can within our power? Are we doing reasonable accommodations? So that's Gittleman. We are forced to take steps administratively. We're not forced to pay to repair things. Despite Civil Code 4760, I am going to advise you not to require owners to improve their or remove improvements to their property. It doesn't turn out well. The people die, the people move on, and chasing them down in order to require them to remove it is just nigh impossible. Okay, next slide, Hannah. Well, then what is the process? So opening an immediate dialogue, Pell Place versus Bumble. This is Peel Place versus Bumble. So we had a situation that goes like this. San Diego has had a 100-year storm. It was a bruiser, and this owner is a cancer survivor. She contacted the association's management office in the middle of the storm and said, my windows are leaking. I expect you to come replace my windows. And the manager said, well, let's hold off here. Let's have a meeting after the storm, at which point the owner started sending videos of the water coming in, 100-mile blast through the weep hole in her windows. So that wasn't quick enough response, apparently, because the manager received a 9-page letter. And I want you to stop there. I want to stop there because we may run out of time along the way, and I don't want to miss this point. Look for passion. If somebody is very passionate about a situation, there's a pretty fair chance that you have a potential fair housing action afloat, a fair housing fact pattern afloat. So again, 9-page letter. At the very last paragraph of the letter, which the manager had circled, it said, and I am the 9-page letter was all about how the window leaked and everything else. So, and I am a cancer survivor, protected class, and I demand that you take some action here. Well, what she demanded was to remove the window. So we got some people together. We talked to the window manufacturer. We then hired a fenestration expert. That is the scientific name for the window expert who does not belong to the manufacturer. And they both actually gave us the same news, which is in 100-mile-an-hour storms, windows leak. And they're sort of made to do that because they're made to drain water through that weep hole at lower wind speeds. And so we, at that point, knew we had a little bit of a problem cooking because we weren't going to replace her windows As a side note, it's a 5-story building. She was on the 5th floor, and it's floor to ceiling windows. So these are probably $16,000 to $20,000 in windows. We brought her in immediately. 3 days after that, we held a hearing. We listened to her. We documented her request, and we documented our responses. And we said, you know, we understand that you're scared. This is fair game. That water might have created a mold condition. Let us come in. We're going to open up your walls. If there is mold, if there is water, if there is a problem, we will remediate it. We'll make it right. And the best thing we did was put that in writing, and you'll understand why. So I think that the board was careful to show genuine compassion to this person. 3 days later, when the vendor wanted to go in and do the work, we couldn't gain access. And so pretty much every 90 days thereafter, I sent a letter to her and said, look, we stand ready to come in and check your place for mold and mildew pursuant to these attached letters from unbiased window experts. What happened here happens. But we do stand ready to come in and investigate the situation and act on behalf of the association, but you're not letting us in. So then about 6 months later, she brought an action through Fair Housing. Fair Housing went through a analysis of our work. They took copies of all of our correspondences. And essentially in the end, we were exonerated. And I talked to the person who made the analysis on behalf of the Fair Housing Department. I said, what did we do right? What did we do wrong? And they said, you didn't do anything wrong. You responded immediately, you responded consistently, and you followed up and offered repair by the association to the extent that the person would allow you to do it. This is textbook. This is how we want you to be. So I want you to understand that we communicate genuine compassion when we listen, and we get creative about how we can make repairs or address access or give assistance to people who are handicapped or who are, maybe being treated differently based on race, color, creed, or national origin. Let's go to the next slide, Hannah. We're already on Geraci. I want to go back a couple of slides because I'll tell you where I want to go. I want to go back to the who can sue because I want to tell a story. I want to tell that story about that. Let's keep going back one more. That's it. I want to talk about Revcock versus Cowpet Bay. If you ever have free time, which none of us do anymore, but it's really fun to go onto the internet and search Cowpet Bay condominiums. They're out in the American Virgin Islands, which is America, and subject to American federal law. And at Cowpet Bay, they have a rule, unlike California, that says absolutely no pets are allowed. And so Miss Revcock and her sister moved in, and they each had dogs, which they claimed were emotional support animals. So there was an intranet at Cowpet Bay, and the owners and tenants and employees and board members would talk back and forth on this intranet, and Miss Revcock became a topic of concern because she had a dog, or they had dogs where nobody else was allowed to. So at the point that Revcock became hated in the community, she sued, and she sued the association, and she sued the board president, who was one of the people who was saying how awful this was. And she sued the individual. Well, what she did was she got on the internet and she told everybody, look, I'm handicapped. This dog is an emotional assistance animal, and you need to stop talking about this because this topic is closed. This is a prescription. This is not a pet, and I am allowed to have it under federal law. And the discussion went on. So when Revcock sued, she sued the manager, she sued the board of directors, she sued the board president, who was, like I said, the head of that discussion group. She sued other owners and tenants who were on the intranet and continued to talk about it. So anxious is the federal government to prosecute people under this sort of private attorney doctrine that the court upheld this action even after Revcock died. After Revcock died, after her sister passed away, the association said, look, there's no more standing. These people are no longer standing. There's no longer a right for these people to bring the lawsuit against all of our owners and tenants and everything else. And the court said, nah, her estate can bring the action. We want this stopped. So I just want you to be aware it's not just a couple of people. Okay, let's head back to where we were before, Hannah, and I'll help you find it. Keep going. So Geraci, so one of the questions that's difficult to deal with for an association, and I'm going to give you a tip on how to handle this, is a situation where we allow handicapped members who document their need for a reasonable accommodation to do something that's against the association's rules and regulations, or Ccnrs, and but don't allow others, because at that point we oftentimes get sued by the others for not allowing them to do it based on selective enforcement. So let me give you an example. At an association that I worked with, we had a American veteran. Guy was a no shit hero. His doctor told us that he needed a jacuzzi in order to do physical therapy after he returned from Afghanistan. And for that reason, he put a jacuzzi on his patio, which was on about the 13th floor of a high-rise building overlooking the beautiful Pacific. So 13th floor, we now get architectural requests from other people. Hey, we want to do this too. It's against the law for us to simply say, listen, we can't allow you to do that. The building isn't built for a lot of this, which we tell them that. But what we can't say when they say, well, wait a minute, that guy's got it. Why can he have it and we can't? Well, we're not allowed to legally say that this person is handicapped, or that the reason that we gave them the jacuzzi was, or allowed them to have the jacuzzi was as a reasonable accommodation. So Geraci versus Union Square is a situation where Geraci was in negotiations with the association for a reasonable accommodation, and the association and then sued. She sued the association after the negotiation. So the association had a meeting and discussed the causes of action against the association based on Geraci's lawsuit. And she sued the association for disclosing her infirmities, and the association defended. And the association defended based on the fact that the lawsuit was public information, and the information in the lawsuit was public. And for that reason, the nature of her handicap and the dispute with the association was no longer a private enforcement action, and could be public to all of the members. And the court said, you know, as long as you stay within the guidelines of what you were sued for, then disclosure has already been made by Geraci. Okay, so we have a disclosure rubric, and we've got a trip hazard here that we've got to deal with. How do you do it? Here's how you do it. When the board approves the jacuzzi, when the board approves the reasonable accommodation, put a sentence in that approval that says, we reserve the right to share the reason why we're allowing this accommodation on the common area, in the public spaces, in the exclusive use area, if we're sued for selective enforcement in the future for failing to allow it for others. That way, the nature, the purpose of the existence of this sort of improvement isn't held against the association in future enforcement actions. Let's go to the next slide. Well, that's the thank you. So now I'm going to turn to the chat, because it looks like there's 16 questions and there's stuff in questions and answers. So I'm going to start in the question and answers and sort of start working through it. So we kicked off with Vicky's question, the handicapped person living here and breaking all of the rules. And the answer is no, the handicapped person is allowed to break the Ccnr's rules and regulations as they exist, precluding his ability or her ability to make full use and enjoyment of the unit. It doesn't mean that now that I have a handicap placard, no rules apply to me. The board waives their rules and regulations and CCNRs, those rules and regulations and CCNRs as are necessary to provide this person a reasonable accommodation. Now, Vicky, your board may not be anxious to tangle with this guy, right? I mean, if they get it wrong, they're going to have the entire state of California suing them. And maybe in the board's opinion, it isn't worth the fight. So that happens. Celeste, yes, age is a protected class. Anonymous, we talked about how to attract diverse applicants to your board. And Nikki, we had a request for a ramp out the front door for wheelchair in response to the board is that we're not obligated under the ADA. Well, that's technically an answer. So a correct answer, they're probably not obligated under the Americans with Disabilities Act, which pertains to a situation where people enter and egress to into a store, a public accommodation, right? But they are obligated under the Fair Housing Act. And so if you requested the ramp, and then you need to sit back down or hire counsel. And what you want to do is have the right to, a lot of people just go forward and install it. I don't like that. I like to try to solve the problem before it becomes a problem. But that is the answer. It's not technically the ADA, it's under Fair Housing Act. David, could you please provide a citation to the Health and Safety Code that requires a pool to be drained the minute a dog enters it? It's in your local county code, Dave. I don't have the local county codes memorized, but it'll be in your local county code. Our association does not permit vacation renters to bring dogs to our units. We had a renter who brought her emotional support dog. We permitted it. She went out to dinner, leaving the dog in the unit. The dog barked all night. What's the best way to prevent that? Well, you did the right thing. And the answer is you should find the renter or find the owner for the renter leaving her dog in the unit and that barked all night. It's not the leaving the dog in. It's not having the dog. It's having the dog bark all night, right? And the way you do it is you go record it. You basically stand outside with a tape recorder and you record it on all of its goodness and greatness, and you then find the owner for allowing it. This is where we're going a lot with the vacation rentals by owner, which is that we are fining the owner. The owner is then passing through a fine to the tenant who uses the space, and then that's stopping the misbehavior. So that's how we're handling noise complaints and VRBOs. How do I inform my HOA of my disability? I broke my leg and wasn't able to bring my garbage cans in front of my gate. I was able to give the West Garbage a note from my doctors explaining that, and they agreed to pick up in my front of the gate. I needed this accommodation for 6 weeks till my leg healed, and I was off crutches. Good. However, my HOA would not let me keep the garbage cans hidden, but in the front yard. What is the process of finding me? What can I do? I think you turn around and you say, hey, look, be informed. Right? I had a disability. This was, the note that I sent. This was the accommodation that was offered to me by the trash company. I'm sorry if you don't find this was a reasonable accommodation. I'd like to meet and confer with you regarding that. And if you continue to find me, I'm going to have to go to the state of California and complain, because essentially that is your right. But you do need to communicate it. So how you do it is just how you did. You just wrote a letter and you tell people that you want to meet and confer regarding that fine. Then an elderly, Nikki is back. I had an elderly female request handicap parking. And it took 6 months to get through the board and override the president's intent to put in a loading zone, just like at an airport. She was using a walker at the time of the request, but eventually a total wheelchair with a caregiver. Sadly, she passed. I'm not sure how long the official handicap spot was put in. The individual on the board Why would we do something for someone who's always gotten her way? I resigned from the board. It was upsetting. Okay, I don't think we have a question there, but it is sad because as somebody who professionally defends these claims, I am oftentimes suspicious that they are just ruses to have your dog, where you want at all times. But I'm equally sensitive to the fact that sometimes people get hurt and injured and are in need of a reasonable accommodation. And I think that it's better if the community, makes some reasonable effort to determine it. But once they determine it, they should move forward to help their neighbors. Who is responsible for paying for reasonable accommodation if modifications are necessary in the common area to comply, boat lifts, ramps, etc.? Well, it's a loaded question, but I tried to hit it early on. And that is that if an individual owner needs a reasonable accommodation to get across the common area, then it is the obligation of that owner to pay for it. Now, you identified lifts at pools. If you have a large enough association under some codes, local codes, they are supposed to put in a lift if you tell them that you're handicapped and that you need it. So you probably want to just talk to your local city or county and find out what the standards are within your city or county. In the Reeves versus Carroll, but back to who's responsible. I don't know what that means, Hannah. But back to that situation again. It's the individual owner's responsibility to pay for it. The association needs to administrate for it. This is really the line. In Reeves versus Carolsberg, how should the HOA have addressed the homeowner's complaint? Sure. Okay. So, fact pattern. I had a owner. So the answer is hold a hearing, an immediate hearing, find out what's going on, and then meet with both parties. So I had a situation like this. Go over to the association, says, hey, I have one owner who's telling me the other owner is throwing rocks at his house. And when we talk to the other owner basically makes a sexual innuendo about the previous owner, i.e. he's a fag or whatever. And so we hold the hearing. I drive past the property. Turns out that the rock E has a rainbow flag on the back of his house. Turns out that the rock thrower does not. Okay, so it seems like this could bear some water as to a potential fair housing action. So we talk to the first guy and we have a sensitive conversation. What's going on? Why do you think it's this? I don't know. I don't know why this is happening, but this guy keeps throwing rocks at my house and everything else. I'm looking at the flag. I don't raise the flag because I'm not going to do that. What I document is he's not aware of why this person's throwing rocks, wants it to stop. We then meet with the rock thrower and I say to the rock thrower, look, are you throwing rocks? And the guy says, no. And I said, oh, good. I'm glad to hear that, because the association's obligated to have this meeting and share with you the problems and tell you not to do it. But once we're done with this meeting, the association's out of this legally, which means that if the behavior continues, the Department of Fair Housing is going to bring a claim against you based on sexual-based harassment. And I want you to know that your homeowner's insurance will not cover that, because actions like that are an intentional action. Discrimination is considered an intentional action, and there's no defense and there's no indemnity through your insurance. So you're going to be paying with first dollar defense. And the guy says, but I didn't do it. And I said, that's great. I'm glad to hear that, because I know that you'll be able to document that you're not doing it, and you'll be able to pay for your defense all the way through the process. And I'm sure that in the end, you won't be found guilty. I will tell you that the last action I defended like this was about $100,000 to defend it and for the association not to be found not guilty. So that is big information for people. once people understand that there is implications for their actions, there's ramifications. I think if you had sat down with Bigot in Reeves versus Carolsberg, I think if you had sat down with the bigot and said, look, we're just going to cross complain against you. You're going to get sued for your action. You're going to pay for your own defense. We're going to be gone. I think that really helps people understand that there's implications for their actions. Can we offer ownership to a person of color because we want a more diverse? I think I've already answered that. If they provide a blue handicap placard, do they still have to have a doctor letter? Great question. And to me, no. They had to provide the doctor letter for the blue handicap placard. So at that point, we are done. As far as I'm concerned, if the state of California knows that these people are handicapped, then I'm content that they are handicapped. Would our HOA 55 be in jeopardy of having an animal policy stating that we comply with the ADA and the Fair Housing Act, since our facilities are not open to the public, should we eliminate compliance with the ADA? Okay, so there's no reason why your 55-year-old, the jeopardy of a 55-year-old community or older community is always that you get more than 20% of the members under the age of 55, and suddenly you don't comply with your 55 plus. So the age restrictions wouldn't matter a dang. Would somebody try to attack your age classification if you are, we got 2 o'clock, we got a little time. Would they bring up your age classification as a reason or challenge it because of the animal policy? No. I would try to say that you comply with all Fair Housing Acts. I don't know why you'd want to not say ADA, but you can take out ADA. I would take out ADA because you're not probably required to. There's some circumstances where residential owners associations are required to, but you should talk to your counsel. They're pretty few and far between. Anonymous attendee. In our community, we have a few known owners that have brought up these issues. Victim of domestic violence and in a protected program has concerns. She is discriminated because of her situation. I understand she's a domestic violence person. I understand she's a protected person. She put this in writing so they did not disclose her need for confidentiality. Well, that's stupid. There's no right to confidentiality when you write to a board of directors. That's like saying, well, I wrote to IBM and so they have an obligation of confidentiality. One of the former board members said at an open meeting that the woman claims she is a stalking domestic violent victim and named her claim as X, and who knows if we can believe anything she says. Person left the room in shock, I'm sure. She notified the board in writing, confirmed they actually heard the meeting. This sounds very personal. No response to the board. Harassment considered through. Yeah, so later the person sued, perfect, for a sexual gender discrimination. The domestic violence felt she was discriminating for disclosing the confidentiality need. Yeah, look, so there's some confusion here, right? Because why in the hell would you disclose to a corporation something that's private to you? I don't understand this. Why would I go tell my homeowners association that I have, that I have a broken leg? I don't understand your question. So my point is that when you disclose something to an association, it's not private. So don't expect it to be private. If the board discovers a homeowner installed a small 5 to 10 foot patio in the common area years ago behind her home, should the board force her to remove it or let her have it as no harms, no, looks nice? It's hard to know because here's the gig. The word is years ago. This isn't a handicap question. This is an enforcement question, Kevin. But generally, if the board becomes aware of something and they take no action for 5 years, then they have it's on the common area. Then the association has the right or doesn't have the right anymore to bring legal action. So there's a 5-year statute of limitations on discovery of a violation of the Ccnrs and then removal. But in this area, and then enforcement against the owner. Okay, so in this case, if the board doesn't want it, they should just remove it. It's sitting on the common area. It's effectively association property. So the owner effectively made a gift to the association in that situation. And I would just remove it, but that's up to that board. Does the associate and their council, does the association need to add an accommodation to a swimming pool for wheelchair bound? Does the association pay or the association? So Nancy, that is local code, and it is fair housing depending on the size of your association. So I can't answer that based on these facts, but generally the bigger the association, yes, the cost of a power lift chair becomes the cost of the association. If you have a 5-member association, it's harder to justify. Regarding access to the community area, curbs are roll curbs, and the homeowner placed a metal ramp at their cost 10 years back, and it works. Suddenly they don't know who they are, remove them and add a cement structure. It's not better than the roll curb, and it took away access to the community area. They refused to correct it. I don't know what the question is. So did a cement structure not better than the roll curb? If you have trouble accessing your unit or making full use of the common area, Christine, then you should go in and tell the board that and tell them, look, we had a good solution here. You took it away, put it back, or we're going to call fair housing. That's kind of what I would do. If a person with a handicap placard takes over the limited handicap parking space to their own empty spot is closed, can other handicap placards claim it is discriminatory for that one tenant to monopolize the parking spot? Good luck. Good luck. This is a very difficult situation. And what we do is we call it competing fair housing claims. And yeah, it's nothing the association should take on. So my sister-in-law is wildly allergic to dogs, and yet owners are required to be allowed to take their dogs on airlines. And so my sister-in-law got onto a plane, and it turned out that on the chair that she sat, a golden retriever flew from New York on the previous flight. So they cleaned the chair and everything, but there was still essence of golden retriever. So my sister-in-law went to the airline and said, hey, one, they had to emergency land the plane, but two, you need to tell me before I get on these planes who's there ahead of me. And the airline effectively looked at her and said, look, you shouldn't fly with us. So we're this competing fair housing claim thing is a big issue, and we don't really know where it's going. Please answer the question again. Is age a protected class? For the third time, age is a protected class. I have a question and have my hand raised, and it's too complicated to type. I'm sorry, Barbara, I'll do the best I can for you. What is your opinion about banning smoking in an HOA? Is it legal? Yes, it is legal. And that's something that's changed in the last 5 years, maybe 7 years. At the point that we got some case law in place, and based on that case law, cities started making smoking within common areas and that kind of stuff illegal. At that point, it became more reasonable for associations to do it, and they have. If you're going to do it in the common area, I think you pass a rule. If you're going to do it in the exclusive use common area or the unit, I think you need to look closer to maybe a Ccnr amendment. And I will tell you that it's a pretty easy Ccnr amendment to get passed because most people absolutely detest the smell of smoke. In general, how do accommodations supersede city, county health and safety codes? Generally, they are allowed because I haven't seen a situation where what somebody wants to do violates the code. I get where you're going. You know, what happens when someone wants to build a ramp and the ramp is more than 2 degrees or 3 degrees? And I think it's fair to require that that they do meet local health and safety codes. Please discuss harassment claim when one party perceives an affront and the other denies the offending behavior and there's no witnesses. So I had this situation where we had, this was funny. So again, a man who wrote a 7-page letter, and at the end he wrote, and I believe this occurred because I think of myself as a homosexual man. And so what occurred? Well, apparently he got on the he got on the elevator, and the allegation is that a board member who absolutely did get on the elevator with him made a bunch of inappropriate comments, including, "We don't like, quote, your kind here," end quote. And so what did we do? We brought them in. We had a hearing with him immediately. We listened to what he had to say. Within 3 days, we met with this guy, and then we met with the board member. And the board member said, "Absolutely not. I never said anything like that. No witnesses." We looked at the tape. There was videotape, but not audio tape in the elevator. And it was clear those two weren't getting along, but we couldn't tell what anybody was saying. And so in the end, it's the same situation as Bigot we talked about earlier. You turn to the board member and you say, "Look, I'm really happy to hear that nothing untoward happened here. Because by meeting with you, the association is sort of absolving itself from this situation. We are telling you that no sort of activity like that can occur. And after that, it's up to you." So that's hopefully, PJ, what you needed. Thomas, I thought that emotional support animals are not regarded as service animals under ADA. They are not. They're their own classification. I just read that an airline started to disallow emotional support dogs on their flights. I've heard that too. I haven't gotten into the weeds on it yet, but I'm happy to hear it. And I think that it will end up getting sued, and then we'll have some good case law on it. Who is responsible to maintain the reasonable accommodation? The person who needed it, Celeste. The person who needed the reasonable accommodation needed it. But in the case where our board went ahead and decided to build a far more substantial ramp, that was really then treated as common area, and from then on out, the association maintained it. Is there an issue with the association proactively reaching out to residents asking if they need accommodation for regular communications? For example, hearing impaired households and how to contact them in emergency, like broker wildline? No. Is there an issue with it? No. I think then an association can do it. But then when you know about it, you better communicate in that manner. And you better make sure that anybody else communicating on behalf of the association communicates in that manner. So Miguel, you may be a manager or a board member, and you may be the very best a person in doing that. The next person who comes through is going to inherit a notebook from you that says, "Hey, when you're talking to unit 102, you need to put it in writing on a sticky, and they'll get it within 24 hours. And the answer is that the board doesn't communicate the next time, you could have some liability there. So it might be more of a problem. Homeowner has an autistic son. His home is at the front gate and the door faces it, and the door faces it. Okay. His son is a runner. When he gets out, escapes several times. Homeowner requested to put up a fence. Homeowner requested to put up a fence to stop him from getting out. It's all the documentation, and they continue to refuse it. Yeah, that's bad for the association. It's good for the owner. I mean, I think the owner should just call the state of California. Is there such thing as a religious accommodation? Yeah, there is. So sometimes once a year, the Jewish people need to live in a tent. And so I regularly allow my associations to allow tents, even though that would be against the CCNRs for that week. And that's fine. If a disabled owner asks for a ramp to be installed so they can walk up the ramp easily and attend monthly board meetings, we have 15 steps now and no ramp. So the answer is, so that owner has the right perhaps to put in a ramp, and the board has the right to require that it be built to standards, ADA and or county standards. Can CCNRs be changed or revised? Yes. Can we stat partition and how many signatures are needed. It depends. Read your CCNRs. Most of the time it is just a majority of the association. Sometimes it's a super majority. So just find out what yours say, and you can go from there. You can also make a legal action if it's super majority. Kevin, smart to encourage board members to ask this question when getting insurance bids. I think Kevin's in the insurance industry because he's absolutely smart. He's absolutely right. Does your insurance bid include coverage for first and third party discrimination claims in the directors and officers policy? Kevin, I'd appreciate if you'd respond, because what I want to know is how common is that? And I will tell you, it is insurance company to insurance company. State Farm absolutely did not cover my last policy, but I had a Indiana casualty or something that did on another association. So it's some do it and some don't. Anonymous attendee, the woman had to disclose to the board that she does not want her information. She just wrote to the board to be given owners are not on the board. I was not clear enough. The sexual discrimination was taken seriously by the board. The outing of the 80-year-old domestic violence. Yeah. What about medical marijuana? Okay, so this is a great topic because it's old and new again. So remember that marijuana is legal in the state of California, and this is where I practice. I'm assuming you're calling in from California about California communities, but so having marijuana is not illegal. Okay, well, we get tired of the smell. Yeah, that's the issue, and that was the issue with medical marijuana. And what I always say is this: look, imagine that you're taking medical marijuana because you have bone cancer, right? And you need medical marijuana in order to make your life better. Well, that doesn't give you a right to spray your prescription all over me. If you were taking Thorazine, if you were taking an antibiotic, that doesn't give you a right to aerial spray your Thorazine or antibiotic over me. So the answer back is, regardless of whether it's medical marijuana or not, the issue is it impeding? Is it causing a nuisance? Is it flowing over to you? And if so, now you have a potential cause of action. Now you have a reason to meet with people. Now you have the right to look at bringing action. What about occupancy codes? I don't know. What about occupancy codes? Jan, I'm not sure if this is the right place, but I'm disabled, have a handicap, placard, cancer, etc. I'm sorry to hear that, Jan. I live on a 0 lot line, so the wall of my garage is part of the lot line, not uncommon. My irrigation timer is on the outside of this wall and is therefore at my neighbor's yard. I share my side yard with my neighbor. Neighbor constantly turned up my water to water our shared side yard and then locked the gate, so I wasn't able to turn down my water. He turned up my water 45 minutes every day. I asked my neighbor to have access to my timer, and he wouldn't allow me access to remove the timer to get inside, move the timer inside my garage. Since my neighbor wouldn't comply, I told the HOA the neighbor wouldn't allow me to access. The HOA said that they will do nothing because it's the neighbor issue. Because of my disability, I wasn't able to climb over his gate. What can I do? Well, yeah, I'm not sure this is a disability issue, right? You shouldn't have to climb over the gate. The issue is that he's not allowing access, and you undoubtedly have an easement or likely have an easement to go do it. I would the easy thing to do is find a way to unplug it and get yourself repiped and get out of this. This is I don't know. I mean, this is odd facts. Do you represent HOA boards only or both sides? I generally only represent HOA boards. I will represent individual homeowners, but you have to, for me, you have to really live in Brentwood or Beverly Hills or something like that. You need to have the means to take on the association. And I don't mean to be a dick here. You need to understand something. Homeowners associations and owners, between them, have a contract, which is the Ccnrs. And under the civil code, an action under the Ccnrs, which includes fair housing actions, needs to or provides for prevailing parties fees. So you have to have enough money to beat the association. You need to, for an owner to sue an association, not for fair housing, because you can get the state of California to do it for free, but in order to sue the association for an architectural issue or something like that, then you need to have enough money to go to the end, because the worst possible scenario is I could have a great cause of action, super, this person was totally wronged, and we could get $25,000, $35,000, $45,000 into the action. And then the client looks at me and says, Mark, I'm out of money. You've got to settle the matter. And at that point, I'm not in a good position to settle the matter, right? So it doesn't do good for my client to start the action unless I know they're gonna go the distance. They is the board. All right. My experience is only about 50% of carriers cover the first and third party discrimination claims in their D&O. I agree. It's smart for the board and their manager to always ask for it and get it. Yeah, that's our insurance guys. And I agree with it. You want to have coverage for this, because it is often not covered. And I think it's going to go away. I think it's going to disappear. Sorry, I wasn't clear. Is it illegal for the board to enforce occupancy codes if more than the allowed amount of people are living in a condominium? We've been advised enforcing occupancy codes would be a violation. It's a difficult thing to enforce occupancy codes, mostly because the proof issue. And I don't know what that has to do with handicapped, but the occupancy codes allow for an incredibly high number of people to live in a unit. A 3-bedroom, 2-bath might allow for 8 people to live in there. So I would go after your county and see if you can go under code enforcement and see if you can get some action that way. But it's very difficult to enforce occupancy codes. So let's go over to the chat.
I just put one in there, Mark, towards at the very bottom. I received that question in an email.
Sending some questions. We have a hard cutoff of 225. HOAs are required to provide reasonable accommodations and must promptly hear your requests. Put it in writing so they can deny unreasonable requests. They need to meet with you. If you're working with an association, I want you to meet with people. Then you can talk about whether a request is reasonable or unreasonable. I believe an excessive cost could be considered unreasonable. Well, it depends who's paying the cost, right? And it sort of depends on the heart of the board for the thing in question. So for example, if an owner comes in and says, gee, I want to do this, and it really only serves them, but they're willing to pay for all of the cost, then the board has almost no excuse, right? The code says you shall. On the other hand, if the owner comes in and says, yeah, I want you to pay for the cost, then the association isn't obligated to pay the cost. So there is no definitive line for reasonableness. That is absolutely true. Are we allowed to, who are you, Nikki? My gracious, everything's got to be anonymous. Are we allowed, maybe we got Nicki Minaj here or something. Are we allowed to offer membership to an applicant because they're a person of color? Well, we did that one already. I understand that if there are dueling disability, accommodation goes to the person who asked for it first. For example, no pet condo and the owner has severe allergies, that would cause a hospital stay and someone wants to go get a service animal next door. Yeah, so what you're saying is that the no pet condo, the owner moved there because they have the handicap and they have severe allergies that would cause them a hospital stay, then that service animal shouldn't go next door. And that may be the case. These things are generally solved at a mediation. So what happens is we end up with a Hobson's choice that really can't be solved. And at that point, the owner typically goes to fair housing. Fair housing comes in and we ask for mediation. So what we do is we say, hey, fair housing, we've tried to resolve this. We have competing accommodations. We don't know how to resolve it. So will you come in and mediate it? And we try basically to quietly step out of the room. And that's been that's been largely successful for us. What accommodations does a 55 plus HOA community designated as an active, and that's special, need to provide for elderly and infirm besides local building codes? None. You're only supposed to hit physical entry and exit. You're not necessarily required to change your programming to meet that. I hope that helps. I'm not sure I answered your question, but you're not required to change all the programming in order to meet that person. Now, should you? Yeah, maybe consider some different classes, right? Beginning, intermediate, and expert, right? That's how my wife does yoga. So that should be it. I think I've hit all the questions. If I haven't, throw them in chat, but it's 2:24, so we're out of time anyway. Listen, I want to thank you guys very much for attending, and I sincerely hope that I've been useful to you and that my answers have demonstrated how the law applies, because I think when you understand how the law applies, you're going to be in the best position to apply it yourself. So I'd like to thank Hannah and Dave Zapponi.
Thank you, Mark. I do. So the only one that we missed we do have just a couple minutes. Barbara had wanted to ask a question. She had actually contacted me before the webinar. I'm going to unmute you, Barbara.
Wow, we get a verbal question. Go ahead, Barbara.
Okay. We had a situation, and some of it you've answered, but a person came to the board meeting and then asked to speak to the board only. So we had her come in closed session, and she said that her roommate, not her roommate, who is not an owner, said that one of the board members actually was slighting her and her girlfriend, and said to her, "Oh, you must be one of those." And the board member said, "No, that never happened. I never said that." And went on to explain that she has many relatives that are gay. So she said, "Yes, you did. This was observed by other people." And so she wanted to have a committee to change the Ccnr to make sure that nobody else called her roommate gay. And it was disagreed with, and there is a big disagreement going on about this, and it's quite difficult. So, being a board member, I was just wondering what can be done about this.
Well, there's a lot of things that can be done. The question is what should be done, right? And so the first thing that I'm going to tell you to do, and it sounds like you kind of did it, but document in the minutes that you held a hearing, right?
We did that, yes.
You held a hearing where that person came in and you discussed what was alleged, and you discussed that and then you discussed it with the director, the person who perpetrated, if you will, or didn't perpetrate, and that person denied it, and that the board didn't have adequate evidence to take further action against that director. But the director was put on notice, and all members were put on notice that, we can't live in a society that discriminates on a basis of race, color, creed, or national origin. Now then the question is, should the board engage in a amendment? Well, that's kind of up to the board, right? I mean, we know that violating the Fair Housing Act is sort of more significant than violating CCNRs. So it would sort of be like, the association passing a CCNR that says thou shalt not kill, right? We know that, right? It's in the Bible, it's in the civil code. Why put it in our CCNRs? But, if it brings pleasure to everybody and helps resolve the matter, and they're willing to make a committee and go door to door to get the thing approved, and it probably costs $2,000 for the association to draft a CCNR amendment, then that might be a solution for your community. And it would certainly show that the board took seriously the allegation and is interested in acting on his behalf. Perhaps a reasonable Compromise would be simply passing a rule saying that the association, takes seriously all, race, color, creed, age, sexual origin, relationships, and will not permit or will not stand for or will encourage, dispute resolution in the event of a discriminatory claim. You should have the law now and maybe some ideas on how to resolve it.
Thank you so much, Mark, and thank you everyone for submitting your questions. I think that's probably the most questions we've ever got through in a webinar. So great job, Mark, and thank you.
Well, thank you. It's a privilege to be here, and it's a privilege to assist ECHO in any way I can. Thank you.
Thank you. And I just want to let everyone know we do have a number of events coming up this month. We have a community conversation coming up next Tuesday on how to save money in your HOA with clean energy solutions. And on January 28th, we have alternative and internal dispute resolutions for HOAs. And then also coming up in February, we have evaluating and hiring your HOA management company. This is a workshop, which will be very exciting. And all of these can be found in the events tab on the ECHO website, and you can click there to register. And I would just like to say one more thank you to our program sponsor for today, HOA Alchemy. And again, from those of you who are not members of ECHO, we encourage you to join us and be part of the ECHO membership community. And if you're interested, you can email jprice@echo-ca.org or call the office 408-297-3246. And thank you everyone for joining us today. We appreciate your time, your questions, and we look forward to seeing you next time. Everyone have a great day.
Thank you.